Good morning, guys. My name is Shiven Asthana. I am a second year law student from WIPS IP Delhi and an intern at LEXIS and Company. So, today I'll be talking about the topic judicial review. So, let's talk about the introduction. The judicial power of the Supreme Court emanates from Section 1, Article 8 of the Constitution. It states that judicial power includes the duty of the courts of justice to settle actual controversies involving rights which are legally demandable and enforceable, and to determine whether or not there has been a grave abuse of discretion amounting to lack or excess of jurisdiction on the part of any branch of instrumentality of the government. Judicial review is the process by which the court declares any law which goes against the Constitution as void. We have adopted this feature from the United States Constitution. So let's talk about the three dimensions of the judicial review. The first is to protect the legality of essential rights under Part 3 of the Indian Constitution. Second, to authorize the disinterest of organizational achievement. Third, interrogation of public interest. There are prerequisites for judicial review, namely, first, there must be an actual case or justiciable controversy before the court. The question before the court must be ripe for adjudication. Third, the person challenging the act must be a proper party. And fourth, the issue of constitutionality must be raised at the earliest unity and must be the very cause or motivation of the case. So let's talk about the timelines, like how the judicial review became a part of the basic structure and how did it came into existence. Like it was adopted during the drafting of the constitution, but how did it face the challenges during the Indian courts, before the Indian courts? So I'll talk about the case. In the landmark case of Keshwanand Bharti versus State of Kerala, the apex court of India propounded the court doctrine of basic structure, according to which it said that the legislature has power to amend the constitution, but such amendments shall not change the basic structure of the constitution. The constitutional bench made no attempt to define the basic structure of the constitution. Chief Justice Sikri mentioned the five basic features. First, supremacy of the constitution, republican and democratic form of government, secular character of the constitution, separation of powers between the legislature, executive and the judiciary. Fifth, federal character of the constitution. Following which, Justice Sikri observed that the basic features are easily distinguishable not only from the preamble but also from the whole scheme of the constitution. He further added that the structure was built on the foundation of dignity and freedom of the individual, which undoubtedly cannot be amended. It was also observed in that case that the above are only illustrative and not exhaustive of all the limitations on the power of amendment of the constitution. The constitutional bench in Indira Nehru Gandhi versus Raj Narayan held that the judicial review in election disputes was not a compulsion, as it is not a part of the basic structure. So following which, the following timelines headed towards in the case of L. Chandra Kumar versus Union of India, the 7-judge constitutional bench stated that the power of the judicial review over legislature action vested in the High Courts under Article 226 and the Supreme Court under Article 32 of the Constitution is an integral part and essential feature of the Constitution, constituting part of its basic structure. In S.P. Sangat Kumar versus Union of India, Justice P.N. Bhagwati, relying on Minerva Mills case, stated that it was well settled and established that the judicial review was a basic and essential feature of the Constitution. If the power of judicial review was absolutely eliminated, the Constitution would lose its basic structure and independence. In Sampat Kumar, the court further added that if a law made under Article 323 were to exclude the jurisdiction of the High Court under Article 226 and 227 without setting up the efficient and effective alternative institutional mechanism for judicial review, it would be violative of the basic structure and hence outside the constituent of a parliament. Let's talk about some facts about the judicial review. So first fact is, judicial review is a type of court proceeding in which a judge reviews the lawfulness of a decision or action made by public body. In other words, judicial reviews are challenge to the way in which a decision has been made, rather than the rights and wrongs of the conclusions reached. It is really not concerned with the conclusions of that process and whether those were right, as long as the right procedures have been followed. The court will not substitute what it thinks is correct decision. This may mean that the public body will be able to make the same decisions again, so long as it does so in a lawful way. If you want to argue a decision that was incorrect, judicial review may not be best for you. Examples for the types of decision which may fall within the range of judicial review include decisions of regulatory bodies, decisions of rights relating to rights of prisoners, certain decisions of the immigration authorities and the immigration of asylum chambers. Let's talk about the extent of judicial review. The initial years of the Supreme Court of India saw the adoption of an approach characterized by caution and circumspection. Being steeped in the British tradition of the limited judicial review, the court generally adopted a pro-legislative stance. The struggle between the two wings of the government continued on other issues, such as the power of amending the constitution. During this era, the legislature sought to bring forth people-oriented socialist measures which, when in conflict with fundamental rights, were frustrated on the upholding of the fundamental rights of the individuals by the Supreme Court. At the time, an effort was made to project the Supreme Court as being concerned only with the interests of proprietary classes, as being insensitive to the needs of the masses. Between 1950 and 1975, the Indian Supreme Court has held mere 100 union and state laws in whole or prior to be unconstitutional. And in some cases, the president powers to issue a proclamation on failure of constitutional machinery in the states, like in Bonmai case, SM Bonmai case, to the highly discretionary exercise of the prerogative pardon, like in Keher Singh case, or the right to go abroad, as in Satwan Singh case. Judicial reviews knows no bound except the restraint of the judges themselves regarding justifiability of an issue in a particular case. I'd like to conclude by saying that accountability is an essential part of the rule of law. It is essential for another reason, as in the earlier editions of Dicey, of course modified in later editions. The judges have a duty to perform, which is even more onerous to keep the judicial ship afloat on the even keel. It must avoid making any ad hoc decision without the foundation of a juristic principle, particularly when the decision appears to break new grounds. And at last, it must always be remembered that a step taken in a direction is fraught with danger of being likely a step in the wrong direction. In order to be a path-breaking trend, it must be a short step in the right direction. Any step satisfying these requirements and setting a new trend to achieve justice can come alone to be called as a new dimension of justice and a true contribution to the growth and development of law, meant to achieve the ideal of justice. Thank you.